Morning, sir. You Pedro Martinez?
Yes.
And this is cause number 26 DCCR 1085. Mr. Martinez is charged with assault, family violence by impeding breath or circulation. Mr. Rojas, what is the announcement?
Judge, if I may, have a name called and document a few things for the court's record.
Sure.
The name of the complainant is Margaret Samano.
Margaret Samano.
Margaret Samano. Margaret Samano. John.
Judge, may the record reflect that the complainant, Ms. Samano, has not appeared in court today. We're not surprised by that. I did make every attempt to reach out to her, known information I also asked my family violence investigator, Ms. Guidry, to reach out to her. It's apparent to us from one, she non-prosecuted, so to speak, in the offense material. And two, I don't believe she has a permanent residence, and they have attempted to track her at some known locations for people who don't have a stable place to reside, unable to do so. We did find one email to her at a Gmail account. We made every attempt to send notification there to please contact us both in English and in Spanish. She has yet to respond, Judge. Obviously, the nature of the offense is concerning with it being a family violence, but on the other hand, the fact that the defendant has been in custody, I feel with that information, it was my duty to, at this time, move to dismiss, and if further information comes to light, I will bring it to the court's attention.
Okay, then I'll sign that. Obviously, Mr. Martinez, I'm taking a look now at that probable cause affidavit. So something went on that night that shouldn't have gone on. And the fact that she isn't cooperating, makes me very concerned, but it is what it is. If you end up back in here, or if she changes her mind, they could re-indict your case, but whatever was going on you need to stay far, far away from that.
Yes.
All right, you can go back with the bailiff.
Thank you, Justin.
I'll sign it as soon as it comes through. Are you Travis Smith? And Mr. Smith was previously in court, entered a plea of guilty to theft of property with previous convictions. And I've received the pre-sentence report. Have you both had an opportunity to review that report?
I've read it, John.
I have, Judge.
Are there any additions or corrections?
No, well, one thing is it's an addition, and I just found out about it Friday. In the report, it says his mother abandoned him at 3, which is true. But she's now straightened herself out, and she's helping run a rehab center in Lafayette, and it's going to become part of his life. He's got 2 uncles here. So he has, they're in the courtroom. He has strong family support,
Okay,
a lot stronger than what that says.
good. Thank you.
Uh,
I am also going to take judicial notice of the court's file. Mr. Smith was previously found not competent, and was sent to the John Dunn Behavioral Science Center and restored competency. Any issues right now before sentencing with competency?
No, I think have you been taking your medicine in jail?
Okay.
I don't think so, yeah.
Okay,
But
perfect.
I'd have to be a psychiatrist to truthfully answer it,
Okay.
correctly answer it.
All right, so Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property with previous convictions. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. But that will be probated for 5 years, so you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That is going to include being on the mental health caseload so that you can get whatever help you need. Follow all of those recommendations, meetings, medication, whatever. That's all part of your probation now. You do all of that. This is a great opportunity for you to get your life back on track. And you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand?
Yeah.
I'm handing you 2 things. One is the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Adams.
Judge's misdemeanor will be dismissed.
Yeah,
Okay,
that's what I was
thank you.
gonna say.
All right, so
You're
they'll
gonna-
get that misdemeanor dismissed as well as part of that this morning. Okay, good luck to you.
Thank you, Honor. He be released today.
He should be,
Yeah.
yeah, as long as there's no other hold that misdemeanor, once if there's nothing else in the other county. But if it's just this, yeah, you should be released today and you'll get some instructions today before you leave the courtroom from probation. To tell you exactly what to do when you're released, okay? Okay,
Thank you, Honor.
yes, sir. Ms. Delays, you have Jeremy Alexander.
Yes, Your Honor.
Good morning. Are you Jamie Story?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Story, in cause number 23, DCCR 1546, I have a motion to revoke your community supervision. Shows that you were placed on probation February 25th of 2025 for the state jail felony offense of theft of property with previous convictions, and that was enhanced to a third-degree felony because of some prior felony offenses. And it looks like the punishment was assessed at 10 years with a 10-year probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report to the probation department January 29th, February 12th, and February 26th of 2026. And is that true or not true?
No.
True or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your contact information. And is that true or not true?
True.
Count 4 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count 5 alleges that you failed to complete the mental health assessment and follow all of those recommendations. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And finally, count 7 alleges that you're behind in your court assessed fees. And is that true or not
True.
true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've made is for a cap of 6 years in prison, which means if I follow that agreement, I can give you 6, I can give you less than 6. It'll all depend on the information that's brought to me when we come back for a sentencing hearing. And is that what you want me to do?
Yes, ma'am.
All right, state tenors number 1.
No objection.
It's admitted any evidence Ms. Story is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come back. All right, you go back with the baby.
Great, thank you.
Judge, my last one is Willie Pugh. He was set yesterday for a suppression hearing.
Let me just-
And that brings us to the end of today's courtroom hearing. One defendant walked out after the state moved to dismiss the family violence charge, while another was given 5 years of probation with strict conditions and a 2-year sentence hanging over him if he violates them. We also saw a probation revocation case where the defendant admitted to all 7 violations, with sentencing still ahead. The big takeaway is that what happens in court doesn't always end with a simple yes or no. Sometimes the conditions, the history, and what happens next can be just as important as the ruling itself. What do you think about the decisions made in these cases? Let me know your thoughts in the comments. If you want more real courtroom proceedings, judge reactions, and case outcomes, make sure to like the video, subscribe, and turn on notifications. Thanks for watching, and I'll see you in the next courtroom. Thanks for watching, and I'll see you in the next courtroom.